Judgment in the matter of Commissioners for His Majesty's Revenue and Customs against Fisher and another, and judgment in the matter of Commissioners for His Majesty's Revenue and Customs against Fisher number 2.
Lady Rose will hand down the judgment.
This appeal concerns the interpretation of the Transfer of Assets Abroad Code set out in the Income and Corporation Taxes Act 1988, which I will refer to as the 1988 Act. The question in this appeal is whether the sale of a betting business from a UK company to a Gibraltar company triggers Section 739 of the 1988 Act in respect of the shareholders of the UK company, so as to impose a tax charge on those shareholders. It is helpful to begin by briefly summarising the relevant legislative provisions. In broad terms, Section 739 is an anti-tax avoidance provision. It applies where an individual who is resident in the United Kingdom transfers assets to a person abroad, with the result that income arising from those assets becomes payable to that person abroad. Where the individual resident in the UK retains the power to enjoy that income, then the income received by the overseas person is treated as the income of the individual resident in the UK and taxed accordingly. The meaning of power to enjoy is defined in the Act and would include, for example, where the individual is able to control how the person abroad spends that money. Where the provision applies, the UK resident individual is then taxed on that income whether or not they've actually received any of the income within this jurisdiction. The effect of Section 739 on a taxpayer can therefore be severe. They can be charged to tax on the whole of the income of the overseas transferee, even if they have received little or no actual income from which to pay that tax. There is a separate provision in the 1988 Act which imposes liability on an individual resident in the UK who has received a benefit because of a transfer of assets outside of the UK, but who did not themselves carry out the transfer. Turning to the facts of the present appeal, Anne and Stephen Fisher are the parents of Peter and Diane Fisher. I will collectively call these individuals the Fishers. The Fishers established a betting business which from 1988 was run through a UK company named Stan James Abingdon Limited. I will refer to it as the Abingdon Company. The Fishers held all the shares in the Abingdon Company and acted as its directors. The Abingdon Company specialised in telebetting, which involves the placing of bets by telephone. The Fishers decided to transfer their betting operations to Gibraltar, which at the time charged a significantly lower rate of betting duty. Betting duty is the tax that had to be paid to the Inland Revenue here on the value of each bet placed. Initially, they set up a branch of the Abingdon Company in Gibraltar, but later they incorporated a new company in Gibraltar, Stan James Gibraltar Limited, which I will refer to as the Gibraltar Company. In the year 2000, the two companies entered into an agreement transferring most of the Abingdon Company's business to the Gibraltar Company. The agreement was signed by Stephen Fisher as director on behalf of the Abingdon Company and Peter Fisher as director on behalf of the Gibraltar Company. And at the time of the transfer, the shareholdings in both companies were held entirely by the Fishers in varying proportions. Following the transfer, HMRC said the effect of the legislation was that HMRC were entitled to treat the profits made by the Gibraltar Company as the deemed income of the Fishers in proportion to their respective shareholdings. That meant that each of Stephen, Anne and Peter had to pay tax as if they had received in the UK a proportion of the Gibraltar Company's profits. HMRC did not seek to tax Diane as she was not a UK resident. The Fishers, excluding Diane, appealed to the first-tier tribunal tax chamber. That tribunal agreed with HMRC that, for the purposes of Section 739, the Fishers should be treated as the transferors of the business sold by the Abingdon Company to the Gibraltar Company. The Upper Tribunal Tax Chamber allowed the Fishers' appeal on the ground, they said, that the transfer of assets had been made by the Abingdon Company and not by the Fishers. The Court of Appeal, by a majority, then allowed HMRC's appeal as regards Stephen and Peter Fisher, holding that they were transferors of the assets which were now generating profits in the hands of the Gibraltar Company. But they held for other reasons that Anne was not liable to pay tax. Both the Fishers and HMRC now appeal to the Supreme Court. The Supreme Court unanimously allows the Fishers' appeal as regards Peter and Stephen and dismisses HMRC's appeal as regards Anne. It holds that the Fishers were not either singly or collectively the transferors of the betting business sold by the Abingdon Company. The first issue is whether it is a requirement of Section 739 that the taxpayer has to be the individual who transferred the assets. The Fishers argue that it is such a requirement, and they rely on a House of Lords decision called Majesty in support of their case. Majesty was decided by the House of Lords in 1980, and so concerned an earlier version of Section 739. HMRC argue that the interpretation upheld in Majesty should not be followed in the present case, as the terms of the 1988 Act differ in important respects from the predecessor legislation that was being examined in Majesty. The Supreme Court holds that Section 739 is limited to charging to tax only individuals who actually transfer assets abroad. That is the most natural interpretation of the wording used in the legislation. The changes made to the legislation since Majesty do not, the Court holds, undermine the reasoning in that case. The severe effect of Section 739 for a taxpayer means that it is inappropriate to apply it to someone who was not the transferor. The presence in Section 742, subsection 9, which extends the reference to an individual in Section 739 to include the spouse of the individual, is inconsistent with HMRC's proposed interpretation. There would be no need for the spousal extension if everyone who has the power to enjoy the income could be charged to tax regardless of whether they were the transferor or not. Similarly, the inclusion now of Section 740, which deals expressly with the liability to tax of non-transferors, but in an importantly different way from Section 739, weighs against a wider interpretation of Section 739. The second issue is whether HMRC is right to say that notwithstanding the legal transferor of the assets was the Abingdon Company and not the Fishers should be treated as the transferors of the assets because together they owned the controlling interest in the Abingdon Company. The Supreme Court holds that Section 739 does not apply to an individual in relation to a transfer made by a company in which they are a shareholder, regardless of the size of their shareholding. There are no principled criteria set out in the statute which can be used to determine the circumstances in which a shareholder should be treated as responsible for a transfer made by a company. In other places in the tax legislation, there are complicated provisions explaining exactly when an individual should be treated as controlling a company, but there are no such provisions here for this purpose. And the existence of multiple transferors for the purpose of Section 739 that would arise if all the shareholders of a company were to be treated as transferors would cause numerous difficulties in applying the provision. The Supreme Court therefore unanimously allows the Fishers' appeal and dismisses HMRC's appeal.
Thank you. The court is now adjourned.